Registering a trademark involves several key stages, from filing the application to examination by the Trademark Office, responding to objections raised by the examiner, a potential show cause hearing, acceptance, and publication in the Trademark Journal. Once the trademark is published, the formal opposition period begins, during which third parties can object to the registration within 4 months. However, what if you believe a recently filed trademark application infringes on your trademark even before the formal opposition period begins? That's where a trademark intervention comes into the picture.
What is a trademark intervention petition? Well, it is a proactive step that allows you to alert the Trademark Office of an infringing trademark application before its publication in the Trademark Journal. A petition is filed against the infringing application where the petitioner provides crucial information and evidence to confirm and establish his first usership. If the claims of the petitioner get accepted, the Trademark Office will drop the infringing application altogether. Let's discuss the legal framework under which this happens.
Law regarding Trademark Intervention Petition. Although the Trademark Act of 1999 doesn't explicitly contain provisions for trademark intervention petitions, the Registrar of Trademarks has the discretionary power to decide on them under Section 128 of the Act. If a petitioner raises objections against an applied mark through an intervention petition, the registrar will be responsible to analyze it, conduct a hearing, and settle the matter accordingly. Hence, it's a common practice to file intervention applications during the pendency of an unpublished trademark. The legal backing for such an action by the registrar comes from the fiduciary duty to prevent the registration of similar trademarks and protect existing IPR rights. Terms like trademark intervention application, trademark intervention petition, and trademark interlocutory petition are often used interchangeably. However, trademark intervention application is the most legally appropriate term, as it accurately reflects the process of intervening in a trademark application due to infringement concerns.
When should a petitioner file trademark intervention? Filing a trademark intervention application is quite flexible in timing. You can file it whenever you find a trademark application intervening with your existing trademark rights, albeit before the application reaches the formal trademark opposition stage and gets published in the Trademark Journal. This flexibility makes it an ideal option to challenge potential infringement concerns and prevent the adverse effect on your brand's reputation even if it is unregistered. Why should a petitioner file trademark intervention? There's no one-size-fits-all scenario for filing a trademark intervention application. The decision hinges on specific case details. Let's explore some examples of when filing such an intervention would be appropriate. Number 1. Identical or similar marks. You have the right to file an intervention against trademark applications that aim to protect a mark similar or identical to yours. Providing evidence of your prior use can help reclaim your exclusive rights. Number 2. Similar goods or services. If a similar mark seeks protection in the same class of goods and services as yours, intervening through an application is justified. This can help mitigate market competition and customer confusion. Number 3. Prior use without registration. Even if your trademark is unregistered, being its prior user grants you exclusive rights. If you spot a trademark application infringing on these rights, filing an intervention is crucial. Simply provide the accurate date and evidence of prior use. Number 4. Well-known trademarks. Well-known trademarks enjoy protection regardless of their registration status. Filing an intervention against any similar trademark application can safeguard its reputation. Number 5. Overall urgency and importance. If a new trademark could significantly damage your business's reputation upon entering the market, early intervention is key. Number 6. Speed of application. If the conflicting trademark application is progressing too swiftly, intervening through an application is the most effective way to halt its official publication. Number 7. Intimation to examiner. Informing the examiner about your claim in the applied mark is crucial. Filing an intervention is the sole method to do so, ensuring the examiner can make an informed decision during the examination stage. Number 8. Cost and time. Filing an intervention saves time and costs for both the petitioner and the applicant. Resolving the matter prior to entering the opposition process is beneficial for all parties involved. Now that you know the basics of trademark intervention application, let's discuss the process.
Process of filing trademark intervention application. The process of filing trademark intervention application is quite legally intricate and needs guidance from professional consultants or service providers. Let's discuss the brief steps you need to take. First, you need to access the application number of the trademark application you're intervening against. Gather supporting documents, such as your trademark registration number and the priority date of trademark use. Once you have these prerequisites, it's time to draft and file the trademark intervention application. Ensure the application is accurately drafted. While there's no prescribed format, it must be comprehensive enough and contain all details to support your claims. You can consult our trademark experts for more information on this. Once drafted, submit the application to the Registrar of Trademarks for further processing. Keep tracking the status of your application. Once it gets approved, the Registrar will take appropriate actions and hold the further processing of the infringing application until all disputes get settled. This brings us to the end of the video. Hopefully, you now have a clear idea about the crucial trademark intervention process that helps you protect your trademark rights at the earliest stages. If you still have questions, let us know in the comments below. You can also reach us directly through the contact details in the description. We'll guide and assist you at every step of the way. Thanks for watching.